From supplementary list, item number 1.
Yes, what is this matter?
May we please your lordship? This related to the drug, it has increased so much, your lordship, even in daytime also very difficult to see some places where the addicts are full. It has gone beyond the control, your lordship. Forget about the night time, your lordship. And earlier that case was there, the PIL was there, initiated by this Honorable High Court, and I was an amicus curiae there. Then we have done a lot of visit to the OST centers and many places, de-addiction center, all those things. So many suggestions were done. Then, in fact, government that time they walked quite a lot. But after closure of this case, now again they have started. So,
Who is for the state, please? So you file a report? You file a report? You call for a report?
yes, your lordship, because mostly your lordship, the problem is that de-addiction center, they promised that they will establish. What is happening, when I went to the OST center, I met the small girls of 14, 15 years old. They say that daytime, we used to lie down here, we take the anti-dose. 5 p.m. they said, you get out from here. Then where we'll go? We have to go to the bazaar to find a...
You are filing this petition in the capacity of amicus or
No, as a counsel of the petitioner is also counsel.
No, is it the same petitioner who was there in 2000, the earlier petition?
Yes.
Same petition?
No, not same petitioner. That is a Meena Kharkar, that was also counsel, a lawyer.
So
On her later,
it should be a fresh petition.
this is fresh.
But I think, okay. And you were the amicus in that matter, correct?
In that.
Okay.
That is PL 13 of 2018.
A fresh public. Yes, the Union of India shall also file a detailed. So in other wherever I visited during this short period, this is the issue that came up for consideration even in our last conference where I attended. So this mental health condition, when it was addressed in the recent conference at Guwahati,
Lordship.
also this drug things, it's common to West Bengal, Meghalaya, and all these districts
All this bill.
because having the international border.
Borders, Lordship is there.
So you have also a great role to play, madam. Please look into it.
Therefore, I prayed your Lordship to declare as a national security. This has become up to date states, your Lordship. If you look Punjab, Haryana, all those.
Yes, Punjab, Haryana has also the same problem.
Punjab was alarming, Lordship, yes.
By drone they are supplying. By drone it's coming.
Please look into it. It's a problem for all of us.
Absolutely, yes.
Deeply obliged. Deeply
Thank
obliged.
you.
From daily list, item number 1.
What was that list? Yes.
May it please your Lordship. Lordship, this is an appeal preferred against the judgment passed by the learned single bench, Lordship. Lordship,
Who is opposing you, madam?
Lordship, the respondent here in Lordship is not being represented, Lordship. Although we have taken steps and duly filed our affidavit of service, but in spite of that, your
What is the
Lordship,
nature of the dispute?
Your Lordship, here in the
Yes.
yes,
Wrong with the judgment. This is only a direction upon you to reconsider. Normally, I do not know about the state of Meghalaya, but in state of West Bengal, we have rules, service rules, which provides that if you are, say, 6 months or 1 year
yes, your Lordship.
due for the retirement, then normally his application for transfer to his place of residence nearby is being allowed. The service rules provides for this. Here, the learned single judge has merely directed you to reconsider his application. So, last leg of posting referring to the paragraphs 37 and 38 of the instruction ROI number 1/2016. So you consider it, madam.
Lordship, if I may draw your Lordship attention to page number 52, your Lordship.
3-2.
52, your Lordship.
Yes.
Lordship, para 38,
Paragraph 38.
38.
Page 32.
Page 52, para 38, your Lordship.
There's no para 38 in page 32, madam.
Lordship, there will be the last leg posting, page number 52. Page 52.
You are supposed to, that's, please ask, since you have been.
Yes, ma'am. We have told you to get instructions on this.
Yes, your Lordship.
Allow him to allow him.
Yes, your Lordship. Lordship, but we are still awaiting instructions from the department pertaining to that, your Lordship.
But in the meantime, the person will retire. It will be infructuous. You cannot keep this matter pending and make it infructuous. We will not allow that, madam.
Lordship will make sure on the next date, your Lordship will come up with an instruction, your Lordship.
How much period is left for the person to retire?
Lordship, he is retiring on 31st of May 2026, your Lordship.
We'll give you 1 week's time. If you don't take any instruction, we'll proceed and dispose of the matter on
Lordship,
merits.
kindly allow 2 weeks' time,
Because we
Lordship.
don't find the judgment to be unreasonable.
Lordship will comply, Lordship.
Sit down. Yes.
Please, my lords. My lords, I'm praying for a little accommodation in this matter, my lords. My instructing counsel who's from Guwahati, my lords, he's in some difficulty.
Sorry?
My instructing counsel from Guwahati, my lords, he's in some difficulty, my lords, which is why I'm unable.
Yes.
Praying for a small accommodation, if my lords kindly.
Yes, tell me.
My lords, if my lords kindly have it after 2 weeks, my lords.
Yes. On the prayer of the Land Council for the appellate.
Let's read.
Yes. Yes.
Yes, Manoj. Well, this is an appeal by the.
You have filed your short notes, but we have not filed any short notes in the file.
No, in fact, I have not yet filed the short notes. I'm carrying my list of dates.
You have filed your short notes.
We haven't, my lord. We haven't.
We gave the direction. It makes us task little easier.
Because there is only one difficulty as far as the short notes are concerned. What I could notice that by virtue of order of 8th of July 2025, my learned friend had filed a rejoinder, which is in the nature of reply to my additional documents. And after that, my lords, the matter was not listed, so I was not given an opportunity to respond to that.
No, additional documents that was not formed part of the writ petition.
Writ petition, and my lords, that was brought to the notice of this honorable court. Thereafter, leave was granted to me under Order 41, Rule 27, in order to do complete justice in the matter. That leave was granted to me. Pursuant to that leave, I filed the additional documents.
No, additional documents was disclosed by you.
By me, my lords.
Those documents were not before the learned single judge.
Learned single judge.
Very well.
In fact, my lord, what had happened was, by the order dated 24th June 2025, Honorable Court was pleased to allow them to file a supplementary paper book, my lord. So on the next date, instead
Now,
of
what is the issue?
the main issue is about regularization of service, my lord.
Regulation of service.
Yes, my lord. This
Now,
is
having regard to the judgment in Jaggu's case,
Yes, ma'am.
is it covered or not covered?
It is covered. It is
covered.
It is
You are for?
the respondent in this matter, my lord. The original.
That's why it is covered.
It is.
And I would say, my lords, it's not covered. It's absolutely not applicable to the facts of this case.
Not 240 days regularly working.
They have been. They have been.
My lords, not here.
Not 240 days regularly working or not? Tell us.
They're contractual, yes, my lords.
Since when they're contractual?
My lords, they have been.
Since when? Please tell us since when.
Their last contract is of 2023.
When they were first.
2020.
2020, my lords. 2020. 2020, they were contractually employed.
In fact, my lord, this is a matter relating to land for employment. So our family has given land to the corporation.
Oh, yes. Yes. Now it has come back to our mind.
Yes.
Yes. So
instead of
the land, what is the scheme? If he gives the land to you, then you cannot apply the hire and fire and you can tell him that, well, you leave the job.
Yes, my lords.
Are you paying any separate compensation to him?
Yes, my lords. That is the point.
Have you paid any separate compensation?
Yes.
Is there?
And that is precisely the additional document that I have filed. That is precisely the additional document that I have filed.
It's basically your land losers employment scheme.
Yes.
Yes, ma'am.
And in fact, my lords, I am the corporation. That scheme is not applicable to me. That is the government scheme. I am the corporation. I am an independent, my lords, corporation, a government company. So that scheme was not applicable to me.
Who is the acquiring body? The state must be.
No,
You are the requiring body.
I have a board of directors.
Are you the requiring body?
Yes.
Then state is the acquiring body.
State is not I am the acquiring body.
You are the acquiring body.
Yes. I am the acquiring, the corporation, which is the electricity distribution corporation, is the acquiring body.
So if you are acquiring, you must have a scheme.
I have a scheme, my lords. There is no codified scheme as far as corporation is concerned. A request was made to the clan that if you are willing, then you can give me the land, and that land should be free of cost. In return, what happened is that they
So you
imposed.
take the free of cost and then you put him in a jeopardy saying that you have been a contractual employee.
No, that's not the case.
That's unfair.
That's not the case. The land is taken thereafter, Milord, that is for the benefit of the inhabitants in that particular locality.
There's a public purpose.
Public
There's
purpose,
There's
public
no problem on that, yes.
So, Milords, what happens thereafter is that as far as the negotiation with the clan is concerned, the clan says that we want a certain yearly rent and we want a certain upfront token amount. That amount was paid by us, which document was not before the learned single judge. We came to know about that document after the judgment was passed, and therefore the leave was sought from this court to produce that document. An amount was paid. So, and as far as the scheme is concerned, the scheme is enacted by the government of Meghalaya. The scheme is not enacted by me. The scheme is designed in such a fashion that only government can implement it. A corporation cannot implement it in various districts of Meghalaya and find a suitable post for anyone. So that scheme was not applicable to me.
So, as you said, and we have understood you correctly, is this: you have a right to acquire.
Yes.
Correct?
Yes.
Normally, the acquiring body is a state, and the requiring body gets it. But then again, it's only the circumstances where you find that you require the land for your purpose.
Yes.
Meaning, thereby, suppose there's a mineral,
Right.
you want to excavate the mineral. Suppose there's a coal.
Yes.
Then possibly what you do, that if you take the land, extract it, then they will lose their land.
Yes.
So there are land loser schemes in various
Right.
parts of India.
Yes, Milords.
Now here, normally what you are saying is for public purpose. Normally that is governed by the Acquisition Act of the state.
Yes.
State will acquire it, pay the compensation and give it to you for your use.
Yes.
Now, if you are, first of all, you have to show us the power of your acquiring.
Yes.
If you don't have a power of acquiring,
Yes.
then you are saying that very well, they may be a very magnanimous, benevolent person. They appeal to your cause and they give you the land free of cost, according to you.
Yes.
But if they have given you the free of cost, then according to your own submission, they are entitled to some employment.
Right.
So it's not kind of a complete voluntary, it's conditional.
It is
Upon you giving him, now there has to be some kind of stability.
right.
It cannot be a hire and fire.
Yes.
Either you should have a notification stating that up to the certain age that they will have a continuity in service with all benefits.
Yes.
We cannot permit a kind of a thing where you take the land for the benefit of public and you don't pay any amount to them, and then you say you justify the action because they will always be under the threat of their being terminated. Because you can very well come and say it's contractual.
Well, if I may submit.
So how we are more concerned with what protective measures are extended to him.
Yes.
So there has to be some kind of protection. Why they filed the writ? They filed the writ, maybe they claim regularization in the apprehension of they being terminated at any point of time. Because if they are regularized, then the question of the service rules would come into play.
Yes.
Then this hire and fire rule would not apply. So as an instrumentality of the state, under Article 12, you have certain obligations to discharge.
Milords.
So you have to take a call on this.
Milords, I
You have to
follow
take a
that.
call on this. So
If your lordship.
you take a call on this, that how you protect their service. Even if you don't regularize them, you have to have some kind of scheme by which their rights are being protected.
Yes, Milords.
Because tomorrow you have a right to dismiss them from service.
Because
And
the
they will have-
the submission that I have, that as far as this case is concerned, this is not a case of any kind of forcible acquisition of land. This was a proposal which was accepted by the clan that they are voluntarily willing to give certain land so that their area is developed, there is substation, there is connection of
No,
electricity.
but then why you give them service? You don't.
Service is absolutely unconnected with the land. There is no document to show that
No, but they are not displaced person from the land.
Milords, that is not before this court, that whether they are displaced persons or not. Those facts are not before us. The service, the employment order employing them, it's an independent notification where 76 people have been contractually employed. And the transaction happened in 2017. The service has been given in 2020. And so it is.
So how the acquisition has any nexus or relevance to their employment in 2020?
No nexus at all. No nexus at all. The employment is completely unconnected with the land acquisition.
My lord, if I can explain this point, my lord, there is a scheme of the state government which my friend is now disowning. That scheme.
No, what he's saying is this:
Yes, ma'am.
that whether that scheme would be applicable to a statutory corporation, it may not be.
My lord, it is
They may-
applicable.
They may adopt it, they may not adopt it.
My lord, in this case, the corporation has adopted it, has wholeheartedly adopted it. In the writ petition which we had filed, besides other aspects, we had raised an Article 14 issue for the reason that 20 other persons have received regular employment under that scheme which my friend is disowning today,
And you are similarly placed.
and I'm similarly placed. It is part of the record at page 52 of the paper book. And that is all we were looking for. The learned single judge, my lord, in the impugned judgment, has only asked them to consider my case, has not even vested any right on me that I am to be regularized.
That's a perfect order, seems to be.
So
It's not creating a right in their favor per se.
they don't have a right, and they don't even have a right for consideration for regularization, Milords. They don't even have a right for consideration.
Let your committee decide it.
No,
If
Milords,
they have said, if they have said that 20 similarly situated, and if they have document to show that there has been an adoption of the scheme, then let the whoever the authority
I can
concerned,
place the facts, Milords. They
let
have.
them consider it and then let them decide the matter. And if you decide it, if you decide the other way, they'll have a right to challenge it.
No, Milords,
Let the decision comes.
there is no right for consideration in this case. They have no case at parity with those 20 people.
No, that's a
That's a-
factual. See,
that's
that's
a
a
factual-
factual aspect of the matter. Let us not go into the factual aspect of the
Yes,
matter.
Milords.
You are not disowning that they are in your employment,
Yes.
correct? They have prima facie, and we are saying they use prima facie. Try to establish that you have adapted the scheme and you have given employment to 20.
Yes.
So this is their case. The learned single judge has merely said that having regard to this, you consider their representation.
Yes, ma'am.
You may accept, you may reject. If you accept, the matter ends. If you reject, then they will have a right of challenge to your decision. So your decision must come.
No, Milords, I follow that. The question is there of consideration, but the point that I am
The
trying to.
consideration is a very innocuous kind of an order.
Yes, Milords,
It
but
does not affect.
But the fact is, Milord, there are so many employees. There is no question of even considering their
There are
regularization.
so many employees is not the issue.
Yes, Milord.
You know the judgment of the Honorable Supreme Court.
Yes, Milord.
In the Hingonari's case, it said that merely because this order is likely to affect thousands of employees, that is not the reason for not giving the benefit to the petitioners.
No, I'm not saying that, Milord. I'm not saying that. I
So you consider, it's better you consider, so you'll have, better you consider. Take down.
Milords, because then allow me, Milords, to come back. Whether
No, we dispose of it, you decide the matter. If you find their case is unmeritorious, you decide because everything is left open by the learned single judge. Nothing conclusive have been decided.
So, Milords, let me then place my case, and then your lordship can pass the same. Let me
No,
place my case.
then we'll decide this matter. We'll not send it to your authority. You make a choice. The choice is yours. If we are against you, we'll direct immediate regularization, which order has not been passed by the learned single judge.
Yes, Milords.
So you have a right to you decide which way you will
Milords, I will address the case on merits, and I will try and persuade your lordship that this is not even a case where any consideration is required.
What is the impugned order? section is the memorandum of 30th August 2017. So there is a clear finding. It's a case of estoppel by conduct. It's a case of estoppel by conduct. So for 20, you have applied this memorandum and given employment. So if they stand on the same footing, being an instrument of the state, you cannot take a different stand.
The 20 people, Milords, that they are trying to take benefit of, it's a different project where there was
It's
certain.
not about the different project.
No,
It's the
though
principle.
the-
It's not a different project. That's why we said that either you consider this on this, or it's a clear case of estoppel by conduct. You cannot, as an instrument of the state, take different stands
the
in respect of different
memorandum is, Milords, subsequent to my transaction. The memorandum did not even exist when the transaction happened. How can they take benefit retrospectively of a memorandum? The Patta, Milords, is dated 23/2017. The memorandum, Milords, is 38/2017.
My lord, the transaction in question is not the transaction of land, but the appointment that we received. We received the appointment after the memorandum, my lord. So we are not challenging
Appointment has nothing
we are
to
not
do
challenging the land transfer, that transaction. We are raising issue with the appointment we received after the memorandum came into force. And para 7 of the impugned judgment has addressed this issue, my lord.
I have prepared brief list of dates.
See, this land were all given during 2015. Now, if your stand is correct, then they are not entitled to any employment.
Yes,
Correct?
yes,
But you have given them employment in 2020.
independently. Yes,
It's
sir.
allow us
2020.
complete our
That is
sentence.
correct, my lords.
But in the meantime, 2017, the government notification had come.
Yes.
That government notification has said, clearly stated, and that should be the thing, how the land is transferred
Yes.
by a registered deed, followed by certain things.
Yes, my lords.
So in their case, have you followed that thing?
Not at all. That
If
is
it's not that, then you return the land.
no.
So void ab initio.
Yes, my lords. That is
You return the land.
no. That is
You
for
have
a
two choices: either you return the land or you keep or
There are
give
two
them the
things,
employment.
Two submissions, my lords. Two submissions. Firstly, the land is transferred to me on a consideration. I have paid the consideration. The consideration document is in my additional affidavit.
What is the consideration?
My lords, yes. My lords, may kindly see that. And they have received it. My lords, in the additional affidavit dated 8/7/2025, your lordship may come to page number 112.
Did they give a reply to this?
Yes, my lord. We have filed a reply. In fact, if I can
Give the
explain.
reply, please.
Yes, and initially, my lords, I had sorted to file a rejoinder, but in any event, I am ready to argue.
Also, here you go. Yeah.
And before my lord sees 112,
Just give us one.
yes.
So have you filed a rejoinder to this?
No, my lords, that is the opportunity that I was seeking, your lordship.
What's the value of the land before the registering authority?
Lords, that I am not aware
That's
of.
important.
Yes, ma'am.
My lord, as on date, it's
Just
about
review of paragraph 5, that is important.
Yes, ma'am.
If you can, if the price of the land is more than what you tender, then what is said in paragraph 5 is applicable.
No, my lords, here the policy as far as 38 to
Forget about the policy.
yes,
If you are saying that it's not a gift,
yes,
and you have outrightly purchased it, then it has to be at a consideration which is with the registering authority of the locality.
my lords.
So what is the price of the land at that point of time?
My lords,
If
that
it is not there, then what is said in paragraph 5 is acceptable.
my lords, I will reply to that paragraph 5.
It cannot be what land.
it's crores.
My lords, it must have been. I take it for that. It must have been more than 1 lakh. But
Then what is said in paragraph 5 is absolutely correct.
paragraph 5, if I may, if I
You cannot be the winner in both the cases.
no, my lords.
You are taking someone's land. Suppose you pay 1 lakh where he is entitled to 3 crores. If it had been an outright purchase, you pay them you don't have to regularize them.
It's
You,
not a-
please. You don't have to give them regularization. You pay them the constitution amount that was prevailing at that point of time. Matter ends.
And my
You
lords,
take instruction.
kindly seize the patta.
We are not looking into anything,
Because
Mr. Counsel.
it's not a.
If you have taken a land,
Yes, my
you
lord.
became the owner of the land. You must have muted your name in the record of rights as the owner of the land,
Yes, my lord.
and you show that this is outright sell. To deny him the right, very well, you pay them the consideration amount as fixed by us, and you finish off. You need not to give them the
My
sell.
lord, just one
The
submission.
choice is yours.
One submission.
We
One
will not allow
submission.
this thing.
No, one submission, my lord. It's not an outright sale. If your lordship sees the land document is in the nature of lease. So I am paying a lease amount. It's not a sale. It's a
lease
15
document.
years.
It's a lease document.
It's a 15
No, it's a
years.
lease document.
It's a lease document.
Which is a lease document? Show us the lease
I
document.
kindly see it, my lord. That is what I am trying to. My lord just sees page 65 of the rate appeal.
65.
Well, because the document speaks for itself.
Right.
Page 65.
First, you don't want us to read the document.
Page
It's a
60.
document. It's a document.
Milord, 65 is, Milord, it is their document. Just Milord, 66 is the typed copy. Is the typed copy.
But,
$64 Milord was that, and 60 translated copy it is written, Milord. That is their document, that's not my document, Milord. And kindly sees, Milord, the conditions. For a period of 15 years, 500 yearly rent. I have made the payment also. It is for the benefit of the inhabitants also. They want to voluntarily give also. So, Milord, in such a situation,
condition.
there is no condition of giving any employment in this in this patta.
You know, the answer to this document is at page 10 of the additional affidavit which was filed.
Everything emanates from this document. And the clan refers to itself as owner. I have to surrender in certain circumstances.
But the condition is that if it's a patta given to you, you
Yes,
claim
ma'am.
this patta was given to you.
Yes, Milord.
This page 2065
Yes, Milord.
is only for agricultural activities and construction of house.
Lordship, this is actually a standard format patta. This 500 rupees was waived
No,
off
that is-
specifically.
Just a minute.
Yes, Milord. Your
If you
Lordship.
go strictly by this document, then only for these activities.
No, Milord, that
And then
construct houses, use the land accordingly as per your wish. As per your wish. But you have to follow the custom. So that is, and there is no objection that I am not following the customs while utilizing the land, Milord.
this document is completely one-sided.
They have drafted, Milord, this document. This is not my document. I have been given this document and my signatures are below. I, Meghalaya Power Distribution Corporation, do accept this patta.
shortchanged. They've been shortchanged. They've been kind of manipulated.
Right. Based upon this document, the OM is not applicable to me, the conditions are not satisfied. After the OM, they accept a contractual employment.
My lord, just to point out that 500 rupees khazana was expressly waived off, my lord.
Expressly?
Waived off.
When?
This is at page 10 of the additional affidavit which my lord had just seen.
This one.
Page 10, my lord. This is a letter that we had issued to the appellant. Lordship will see with reference to the subject, etc. Mutual decision has been taken to waive off the khazna of rupees 500, which was mentioned earlier for the early construction of so-and-so. 500 rupees has been waived off.
And 1 lakh has been accepted.
1 lakh has been accepted. That is for the patta, my lord. That is normal practice. That is only for the
If
patta.
I calculate,
that is not for the transfer of the land, my lord. Sometimes we take 1 rupees as a token
So
amount.
these documents are not before the learned single judge.
This document was not valid. And in fact, if I can humbly point out from the document itself at page 12 of the additional affidavit.
So for 15 years, you have to pay just 1 lakh.
My lords, if I calculate from 2017 to 2025, it will be hardly 5,000 rupees. 1 lakh of consideration has been paid to them. As per their asking, they asked, we want 1 lakh, 1 lakh has been given.
My lord, the distinction.
This cost of patta would mean the cost of patta would mean the cost of land. Patta is the document. The cost of patta is 1 lakh. No, but then what is your position as of now? This 1 lakh patta, if it is paid to you, you became the owner.
I am not the owner, my lords. I am governed by the patta. I cannot go beyond the patta. I have a 15-year lease of that nature, and after
So instead of 500 rupees per month,
I have paid 1 lakh.
no, instead of 500 rupees per month, which will be around say 6,000 rupees a year.
Per year.
500 rupees per year.
Per year.
500 rupees per year.
Per year.
And so 1 lakh you will be paying for it's a considered amount for the 15 years.
15 years. That's the consideration
My lord,
that I have paid.
this is completely
Consideration
incorrect.
For what?
My lord,
Consideration for permissive use. Consideration as the owner. What is the consideration?
My lords,
the
it will
distinction-
be
Because
consideration.
there is no agreement between you and him.
my lord, the distinction between the cost for the patta and the consideration for the transfer of the land, there is a very clear distinction, and it is a distinction that they have recognized in their own documents. If Lordship kindly looks at page 9 of the additional affidavit, which Lordship has just seen, it is a letter issued by them, clearly demarcating these two aspects. that we have to pay 1 lakh for the patta and 500 rupees as annual khazana. Subsequently, 500 was waived off. Finally, the payment that was conducted through page 12, the document through page 12 itself says, we are paying 1 lakh to so-and-so on account of patta on the donated land. Patta on the donated land. So 1 lakh has been paid only as cost of the patta, which is normal practice amongst these traditional families. Sometimes, as I said, we take a token amount of 1 rupee. From the corporation, we have taken 1 lakh rupees. But that is not consideration for the transfer. They themselves recognize that it is donated land. And they are paying 1 lakh for the patta on the donated land. These are two distinct aspects, my lord. Price of the patta could have been 1 rupee. In their case, it's 1 lakh. Price for the...
No, patta is basically will be the document of title.
Yes.
Yes, my lord.
It's a document of title.
Yes, my lord.
So if you say that 1 lakh rupees
is only for the issuance of the patta. In registry offices, maybe they...
the cost of patta, what does it mean? Cost of patta is a consideration.
No, it is only we may call it a processing fee for the issuance of the patta. As I said, sometimes we take 1 rupee as token amount. In the case of the corporation, we have taken 1 lakh.
That is for the who is to decide on this?
My lord, the family decides. The elders of the family, they decide how much should be the patta cost for this particular transaction. Considering that it was the corporation who was requiring the land to set up their substation. And substation, my lord, it's a permanent structure. Once we've given the land, my lord, de facto they've become the owners of the land, irrespective of what the document says, my lord. So to answer Lordship's question, my lord, consideration price is to be decided by the elders of the family. Certain cases, 1 rupee is the decision taken. In their case, it was 1 lakh, but only for the issuance of the patta. There was no consideration for the transferring of the land, either by way of, you call it a lease, my lord, or a sale, an outright sale. There was no consideration. They have recognized that distinction, my lord, through their own documents. They are saying, we are paying you 1 lakh for the patta on the donated land. They are recognizing that land as donated land. So once we have donated the land, all other arguments, my lord, are neither here nor there, my lord. They fail. Once they have recognized themselves that we have donated the land. So that 500 rupees, my lord, that was a misdirection. We have waived off that 500 rupees. There is no consideration till today that we have received. Not a single rupee.
Which consideration?
Till today, my lord, we have not received any consideration.
1 lakh you have received.
One for the cost of the patta. That much we have received. But that 500 rupees, which my friend has alluded to,
That seems to have been waived.
that has been waived. We have not received anything in that respect, in respect of the transfer.
If you have waived, then there is no question of you receiving the amount.
Naturally.
So this 1 lakh practically you have received for your 15 years lease.
Only for the document, my lord, for issuing that document, the patta.
I fail, Milords, with utmost respect, I fail to see the distinction, Milords. Once a consideration has been paid, good or bad consideration has been paid for that lease document. Milords, these aspects that there is an artificial distinction, there is a cost for a patta, thereafter there is some other consideration, Milords, that is completely beyond law.
Are these documents admissible in evidence?
Milords,
Does this create a lease in your favor? Under the Transfer of Property Act, I hope the Transfer of Property Act applies to the state of Meghalaya.
yes, Milords, it does.
So, will it create under 107 of the Transfer of Property Act? On what basis you will exercise your right?
But on the basis of this document only, it is, Milords,
It's an unregistered document.
it's an unregistered document, and I will indicate the reason why it is unregistered document. Milords just sees the correspondence in this regard. What we did, Milords, after the waiving off of 500, we asked them to issue a fresh patta. That would have been registered and stamped. But that was not done. So today the relationship between the parties is governed by this agreement. And the clan is not before your lordship. These two petitioners are there who want to claim some benefit out of the land which was given by the clan.
Now, their lands have been taken.
The clan's land have been taken. They have no individual right on that. The clan owns the land.
I am a part of that family, my lord. My family's land has been taken, for which I was supposed to be appointed, my lord. I have received
Supposed to be a?
appointed, my lord. I have received contractual appointment, which lordship has noticed.
But then what basis you give them the appointment if he is such a...
Well, that's an independence. If I can show your
No,
lordship,
what is the letter of appointment?
my lords, there is a notification that is there of 2020, and thereafter there is a 2023 agreement on record, which entirely says the employment relationship between the parties will be solely governed by this contract. The petitioners alter their position and accept a contractual employment in 2023. And today they come to the court and say that I want a regular employment. Way back in 2017, my client had given certain lines.
No, show us the letter of appointment.
My lord, just sees the 2023 agreement.
No, please show us the letter of appointment. We want to see the letter of appointment.
There, my lords, if your lordship sees,
Page 33 of the paper book.
67 of the appeal paper. 61. So, my lord, this is a notification of the Power Distribution Corporation dated 22nd of July 2020. In pursuance of the office order dated...
So, this contractual employment was on the basis of any public advertisement or...
Yes, my lord. In pursuance of office order dated 1/7/2020.
Where is that office order?
My lord, unfortunately, that office order is not on record. And your lordship can see that 76 such people have been given contractual employment in this notification itself. And the petitioners are at item 53 and 54 at page 68.
But that is relevant because it is issued by you.
Yes, my lord.
So if you are relying upon this, it is for you to disclose this document.
Yes, my lord. If your lordship permits, I can...
No, it's not.
That is not
you.
on record. That is not on
You are relying upon a particular memorandum. It is for you to disclose that on the basis of that memorandum, whether their appointment was in terms of that or not, or whether they have an independent right or not.
Yes, my lord.
So what is that memorandum? You disclose the memorandum.
Well, we'll disclose the memorandum, but I have instructions. I have taken instructions on this point. This is an independent
Forget about it.
notification.
Your instruction will not do. You want to see the document because you refer to the document in your letter.
Yes,
Right
my
on.
lord.
The learned counsel for the appellant has relied upon
Number 4 to 11.
But the counter affidavit has been filed yesterday by the respondent number 1 in these matters.
What is this matter, please?
Well, this pertains to, it's an intercourt appeal, from the learned orders of the learned single judge. The issue in hand is, whether, the Meghalaya Electricity Regulatory Commission has the powers to pass, orders with retrospective effect. The issue of retrospectivity is the issue here, There were two issues, before the learned single judge, whether, the commission has the powers to recall its orders and the issue of retrospectivity. That's the larger issue, I was praying if your lordships grant us some time, we'll examine this affidavit which has been filed. And we'll also file a written notes of argument. Your lordships may kindly fix a date on which we can conclude the argument. This matter will take a little time,
No, but how long will it take to file an affidavit?
It's a week's time should be good enough,
Now, the issue is that learned single judge has dismissed the writ petition on the ground that there is an alternative efficacious remedy under the Electricity Act to file appeal before the applicant.
That's one of the issues, We were contesting that.
That is the core issue, my lord, because that is the core issue. If
There is an appellate forum,
yes,
then
what our case is, that the issue of
but whatever the issues you have raised here,
Melons,
if those issues can be raised before the appellate forum,
we are saying it cannot be. We'll try and persuade your
no,
lordships.
if there is existence of alternative remedy, the law is very clear on this.
We'll try and distinguish
If there is a
ourselves.
violation of the natural justice.
yes, ma'am.
If the statutory authority does not have the power, there is a
We come under that
does not
exception.
have the power in the sense of the exercise of jurisdiction is itself.
Wholly without it. Wholly without it.
That is our case.
No, you cannot say that your case is that they have applied it retrospectively.
No, there are two issues as I
No,
submitted.
the issue that you have raised,
Two issues, One is whether you can recall your own order.
no, that's a different issue.
Malins.
Recalling is there or not is a jurisdiction issue which the appellate authority can decide. It's not going into the root of the jurisdiction.
Lordships.
And the other thing is this, that
Retrospectivity.
both matters can be decided by the appellate authority.
We'll try and persuade my lords.
Why should we? It's an efficacious alternative remedy. You try there. If you fail, we are always there to decide.
At this stage, I am only praying lordships may kindly
Because
grant
it's
me
all
liberty to
law is
file
well
this
settled.
plan.
If you see the decision of the Calcutta High Court Division Bench in ITC's case,
ITC.
it's a judgment of Justice Subhash Chandra Sen, whose lordship later elevated to the Supreme Court, along with Justice Umesh Chandra Banerjee. I think ITC.
Yes, ma'am.
And before that, even Whirlpool is there.
Whirlpool. We're trying to carve out our case within the exceptions of Whirlpool.
Go that.
Infra petita, my lord, it's not ultra petita. Within the error within the jurisdiction.
Yes, error within jurisdiction correctable by the higher forum is different from inherent lack of jurisdiction. So it's not a case of inherent lack of jurisdiction.
We are trying to come within the
lack of
exception
jurisdiction. You see the judgment in Isaac by the Supreme Court.
I'm conscious of that, I'm on a very sticky wicket, but I'll have to.
Not sick, we thought of disposing of the matter.
May kindly have it on the 30th, if it's not inconvenient.
30th. Very well.
We'll file a...
See the judgment in the ITC.
This one fact here that the same party has filed an appeal, my lords, against the next tariff order before the
I
appellate
can't see
tribunal.
We
anyone.
have already went on.
Sorry,
I
can you
can't see
lordships-
anyone.
can you lordships- Am I audible, my lords?
You are audible, but you are not,
Not
visible.
visible.
Not visible.
I can't see anyone. I think these are not working. But I can't
No,
see anyone.
the monitors are not working today.
I can't see
For some
anyone.
reason.
We can't see it.
My lords, may kindly have it on the 30th, if it is not inconvenient.
I just wanted to point out, my lords, that I'm appearing for the commission. The other party has filed, the
My
same
lords, my
party has
learned
filed an
friend
appeal.
is appearing for
You are for
respondent.
the commission. Commission is
I'm for the
not
commission.
to be heard.
Commission is.
That's all. I wanted to
to be
point out
heard.
there's an appeal already. pending.
Commission is not a necessary party.
Yes, yes.
Why you have made
But
commission?
they have.
This formal party,
This is contrary to the Supreme Court judgment.
Yes, because
we have pointed this out.
They have placed allegations against.
Tomorrow you'll make a judge a party and assume you have prepared an
There's no allegation of malfeasance.
no, Justice Sagir Ahmed's judgment is very clear on that issue.
You don't require the commission to be the party.
Just a formal party.
Yes.
Unless you have make a specific allegation against any of the members of the commission
Violence.
about bias or another thing.
Yes,
Violence.
yes.
No, that's not the case, my lords.
Yes, so we can delete you.
I'm more than happy, my lords.
Unless you want your appearance on 30th. Choice is yours.
No,
So
Milord,
tell us if you
Milord, I
want
won't get.
deletion. So please tell us if you
Fine.
want deletion, we can here and now delete you. Or if you
No,
want to
Milord,
wait
what had
till
happened
the
was
end.
in the first round of litigation, Milord, before the learned single judge, my esteemed senior from the petitioner's side had argued that the commission had no jurisdiction to recall its order. And that is why perhaps we were made
You
a
are
party and we were part.
you are body neutral, so you
Body
should not.
neutral, body
you
neutral.
I'm
are-
body neutral.
it's a
Only on
body
my power
neutral.
will
It's
that
best if Malaz will permit us
No,
to.
this very point that whether power can recall. You see that I think
This
a
Noida
judgment-
authority judgment is there.
no, there is a judgment of the Supreme Court itself,
Yes.
where the statutory authority is there. Because if you as a creature of a statute and its power
Work
of
within the
recall,
four corners of the statute.
accepting the Greenless Bank judgment,
Brilliant bank.
1981 Supreme Court,
Lordships.
except in the Greenless Bank judgment,
Lordships.
the power to recall was considered by the Honorable Supreme Court in the context of Industrial Disputes Act.
True, Malaz.
But there are subsequent judgments in the Consumer Protection Act where the power of recalling was considered.
Yes, madam.
So, but then again, these are the issues.
Lord,
Power to
and so
recall.
far as power of recall is concerned, they have expressly given up this point in before your lordship. The order has recorded that they do not want to question that ground.
So, on the merits, I think that you should go because you are not remediless. You would have understood that you would have been remediless. So, if you are not remediless, then the appropriate authority should consider this because they will be more conversant with the facts and the law on this aspect. Because they are a regulatory authority specially constituted for this purpose.
Yes,
True, Malaz.
So these
We'll
authorities,
examine
and that
this,
is precisely what Isaac's decision is there in, I
Isaac.
think, 1992 or 1993 Supreme Court. It's also
Isaac and ITC, Malaz. We'll examine both.
Isaac, I can't recollect the entire full name.
Malaz.
And the discretion is the judgment of Justice Subbarao, as his
That's
lordship
the
then
Subaru's
was.
decision, Malaz.
I think in 1966 Supreme Court.
That we have cited, Malaz.
Yes,
Before the
1966 Supreme Court, but that again,
Malaz.
that again has a rider.
It comes with the right, Malaz. We pointed it out. That was argued before the learned single judge. As your lordships have rightly said, it would have to work within the four corners of the statute.
ITC judgment has laid down the three principles following the Whirlpool is there.
Yes.
I think Whirlpool is subsequent.
Yes.
ITC is earlier.
Prior to Whirlpool.
I think this is in 1991 or 1990, possibly reported in ELT also, excess law times.
We'll place that judgment.
No, please consider whether it's relevant or
Malaz,
not.
we'll assist your lordships. We'll run through.
But I think we can dispose of this matter, Mr. Counsel. You take, we'll give you the time to file the appeal and we'll direct them to consider this because any event the appeal lies before us, maybe.
Malaz, under the Act, Malaz, then it would
It
go.
goes to the Honorable Supreme
Oh, then fine. Okay, thank you.
Malaz would have it on
So,
the 30th. Then,
when should we keep it?
Malaz, would it be convenient on the 30th?
30th you want?
Would, if convenient, Malaz.
No. I'm here. What can I do? Here to decide the matter. You want on 30th October, correct?
Malaz.
Sit down. We have heard the Land Council for the parties. The question.
Item number 1.
Yes.
Meet, please, Your Lordship. I have covered the major portion of my argument, my Lord. Your Lordship, kindly take my note of submission on the appellant. One point was missed out, my Lord. And page 16, where, my Lord, I have taken up the argument of Article 1419. Page 16.
Now, please tell us how you distinguish the division bench judgment in the Meghalaya matter decided by Justice Amitabh Roy.
Yes, ma'am. That's a core issue. Now, the judgment Your Lordship has seen is proceeds on the premise.
Give the judgments, please.
That judgment Your Lordship will find
Copies of all the judgments, please.
in volume 1, my Lord. At page 121.
Yes.
Lordship, and the judgment starts from page 124.
Yes.
And Your Lordship has noted that the division bench of the Honorable High Court has referred to various judgments, including the stand of the state government, paragraph 20. And paragraph 20, if Your Lordship will kindly see at page 132, last two lines, Your Lordship, of paragraph 20 at page 132.
See, if you come to paragraph 11
Yes.
of the same judgment.
Counsel in its counter numbers has, while affirming the age-old practice of levy and collection of customary tolls by Khasi chiefs on items of merchandise on transit of ilakas, under them has maintained that the same has been saved by constitution and has attained a force of rule which had since been codified under the Rule 2006.
What is this rule? What is this rule of 2006?
Rule 2006 is, my Lord, that Rule 2006 has been defined Khasi CMC rule.
My Lord, I have to compile those rules. I just supply the copies
Yes.
for the convenience.
Name is Administration of Nongstein CMC Rule 2006.
My Lord, the rules will be available at page number 7.
So this is with regard to election.
But elections and the collection of the tolls is there. Page number 7 is the rules. My Lord, short title extent commencement. Page number 7. This rule should be called as administration notes to an.
Yes, customary tolls is there very well.
Yes. And if my Lord go to page number 9, customary tolls, details are there. Learned HM.
Yes, customary toll, my Lord,
Yes.
means the tolls levied and collected by CMs and his darbar on merchandise.
Yes.
Page 9, my learned friend has placed that rule, my Lord. Customary tolls means tolls levied and collected by CM and his darbar on all merchandise in accordance with the established customs and uses prevailing in CMship since time immemorial and hereto, which includes, these are the type of tolls.
Yes. So,
Including, your Lordship will find that Roman ka kheva means a type of customary tolls levied on merchandise relating to mineral produce that enter inside the CMship market or transported to the external market.
you are reading? You are reading?
I am reading, my Lord, is I at page 229 is the right side page, and customary toll is Roman 33 I.
Yes, that we have read. Yes,
Yes.
yes.
Type of customary toll levied on merchandise relating to mineral produce that enter inside the CMC market transport market. Now, the question which calls for lordship's consideration.
Yes.
By virtue of this customary practice, which have also formed part of the rules, Milo.
Yes.
Whether the district council authorities, because these are all by Khasi Hill Autonomous District Council. These rules have been framed by. In paragraph 3, your lordship has seen that Khasi Hill Autonomous District Council has no power to levy tolls or collect dues on minerals passing through the Ilaka.
No, you see that this is called the Khasi Hills Autonomous District Nomination
Yes.
Act of 2003.
Yes, my lord. Act of 2003.
Now,
in Act of 2003,
no, this is in pursuance of paragraph 11
paragraph 11, if
of
your
the
lordship,
6th schedule
Yes,
of the
madam.
Constitution of India. The following Act of Khashi such and such is hereby published.
yes, your lordship, kindly see paragraph 11.
11 of the 6th schedule.
6 schedule, paragraph 11 of 6. This is on, paragraph 11 is only in respect of notification. Right to make laws are in paragraph 3. Paragraph 11 is publication of laws, rules and regulations made under the schedule, my lord. And power to assess and collect land revenue and impose taxes are in paragraph 8, my lord.
No, this is power to assess and collect land revenue.
And impose taxes. And in various subheads of taxation entries, my lord, you also will find in subparagraph 3.
No, paragraph 11 says all laws, rules, and regulations
Yes, my lord.
made under this schedule by district council or regional council shall be published forthwith in the official gazette of the state
Yes, my lord.
and shall not such publication have the force of law.
Yes, my lord.
So here, the district council or the regional council, as the case may be,
Yes, my lord.
they have their executive and legislative function.
Yes, my lord.
So they have the executive and legislative function.
Yes, my lord.
And as soon as they pass it, it does not require even the signature of the governor.
Yes, it requires, my lord. That
requires.
it requires, my lord, and that you also will find without consent of the governor, it will not have force of law, my lord. Which is there? Paragraph
3.
Paragraph 8, subparagraph 4, my lord. Paragraph 8, subparagraph 4, where consent of governor is required, my lord. A regional council or district council, as the case may be, may make regulation to provide levy, and every such regulation shall be submitted forthwith to governor until assented by him, shall have no effect.
So this act, when it was there, it was placed before the governor
Yes, my lord.
and assented to by him.
Yes, my lord. That is there.
So this act gives them this act says two things.
Yes, my lord.
One is it recognizes customary right to collect tolls.
Yes, my lord.
And secondly, that this was a custom.
Yes, my lord.
One is a right and as a custom.
Yes, my lord.
So this is of 2006 regulation
Yes, my lord.
or 3, the 2003.
Yes, 2003, my lord.
So if this is a customary right,
Yes, my lord.
then how this can be prevented?
Yes, my lord. Now the question is, my lord, before your lordship, that customary rights can impinge on the customary rights can't go beyond the constitutional scheme, my lord. Customs are under Article 13. Your Lordship will kindly see Article 13, where custom has been recognized as law. 13(3)(a), my lord. Law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of the force of law.
Yes.
So custom, if it is repugnant,
No, repugnance should come later because this will not come within the purview of any repugnancy. Because custom stands independent of any right. It's neither a state or a union. So if the sixth schedule gives power to the district council or the regional council as an executive authority and also to legislate,
yes, my lord.
so the legislation is of 2005.
Yes, my lord.
That legislation received the assent of the governor.
Yes, my lord.
State has considered to the state situation.
Yes, my lord.
And if the state has considered to the situation and it recognizes that it was a custom and they have a customary right.
Yes, my lord.
So this is said by 13(3)(a).
Now 33(a), my lord, will save the rights, customary rights, which are within the powers of the custom. Assuming, my lord, the custom is that custom has been recognized by the state. For example, in this case, we have recognized certain customary practices which are not wasted even in the state.
No, if a custom is not opposed to the constitution, scheme
Yes, my
of
lord.
things,
Yes, then it will be certainly recognized. And on this issue, my lord, direct judgment,
for
because
example, suppose custom says human sacrifice during a worship,
yes, my lord.
that cannot be allowed even if it is a custom. So 13(2) does not.
These provisions fell for consideration of Supreme Court. These acts also, in all the Masa judgment, my lord, that judgment, your lordship kindly have that judgment, where all these provisions have been noted, where in respect of mines and minerals, these laws were cited before the Honorable Supreme Court to say that we have a right in controlling the activities relating to mines and minerals. And if your lordship will kindly see that judgment, all the Masa judgment, which is at page, lordship will find that judgment at page 18 of the volume 1. And the relevant part of the judgment which deals with this aspect of the matter.
What is the name of the case?
Case is State of Meghalaya versus All the Masa Students Union, Dima Hasao District Committee, 2019, 8 SCC 177, page 18 of volume 1, my lord.
Yes.
Because in this case, my lord, the issue arose whether MMDR Act is applicable to the state of Meghalaya or not. Paragraph 142, your lordship kindly see page, paragraph 142. Point number 6, my lord. At page 95. And 146, my lord, last three lines. And moreover, my lord, this issue whether they have power to and one more judgment, my lord, of
But
the Supreme.
here you see that the issue was whether
Yes, my lord.
the district council have the power to grant mining lease.
Yes,
But
yes,
we are concerned with the power of the district council or rather the tribal people to
Yes,
collect
madam.
the toll fees.
by district council only, my lord. These
the
powers have been recognized by district council under the act framed by district council.
District council has not given him any power.
Your lordship, this act is by district council only.
Yes, the district council has made
Recognized
2005
customary,
so it recognized.
recognized through the act.
So if 2005 acts of Meghalaya government has accepted,
Yes, my lord.
and there also you will find
Yes, my lord.
in that act itself,
Yes, my lord.
there is a specific provision
At page
for
9.
the minerals as well.
Yes, page 9.
Yes, so that 9 itself, rule 9,
Yes, customary
Down
drawn
the
levy
line.
on. Yes, my lord.
first one is your toll fee, and I think 8th or 9th is your mining.
Yes, enter inside this for transportation to. Yes, my lord. 9. I mean the type of levy number relating to mineral produced that enter inside.
Hakhewa means a type of customary toll levied on merchandise relating to mineral produce that enter inside the seamanship market or transported to the external market.
My lord. So this is, it has to go to the market
Or to the external market.
or originating from the external market. Nature of customary dues is also different what is being paid for. And one more aspect, my lord.
Yes.
Yes, my lord. One more aspect, my lord. The Supreme Court has occasion to examine the power of the district council to levy or impose taxes. In the judgment, my lord, of District Council Javai versus Devet Singh Rambai, 1986, 4 SEC, page 38, para 11, which is in 196, volume 2, my lord. 196. The judgment is on 196, your lordship. Volume 2. 196 and relevant paragraph will also find at paragraph 11. At page 203.
Yes.
So there is no plenary power, my lord.
Yes.
So my submission based on two judgments and reading of the paragraph 3, paragraph 8 of the 6th rule of the Constitution is that the customary right cannot extend
Yes.
to levy toll on movement of minerals passing through respective ilakas. The acts framed by district council cannot go beyond the powers which are conferred on district council under paragraph 3 and paragraph 8. Even the custom, independent of the act also, customary practice cannot be in violation to the provisions of the Constitution. Because toll, your lordship knows that toll is a compensatory mechanism. You have to compensate the person from whom you are collecting the toll, either you make the road or bridge, etc. And for that, my lord, I rely on Indian Toll Act also, 1851. That was not part of my written submission, but and there are two judgments relating to Indian Toll Act. My lord. Now, your lordship, kindly see the Indian Toll Act of 1851 and section 2, my lord. Section 2, and this has been explained. Nature of toll, my lord, in NBCC versus State of West Bengal, my lord, 2025, 3 SSC 440, my lord, which judgment starts at page 440, sorry.
This you are showing what?
Yeah, I'm sorry, brother. This lordship kindly come to page 53 of the compilation. And paragraph 54, paragraph 34 at page 53. The state is not obvious, Your Lordship, first line. Page 53, paragraph 34. And 35, you know.
Yes.
So, even if they're collecting toll, my lord, assuming my alternative argument, it cannot be in the nature of tax. And moreover, it is covered by the parliamentary legislation of Indian Toll Act. And paragraph 12A of the 6 schedules clearly says that in case of repugnancy, parliamentary act will prevail, my lord. Paragraph 12A, my lord, of the 6th schedule. Application of acts of parliament and of legislature of the state of Meghalaya, my lord, to autonomous districts and autonomous region in the state of Meghalaya. And this is overriding provision, my lord, notwithstanding anything in this constitution. So, to the extent.
So which state law, their regulation is in violation of which state law?
First, it is in violation of, my lord, the Indian Indian Toll Act 1851, my lord.
I was not even aware that this the state law.
Yes, my lord. When I started researching on toll, so we got the judgment.
No, but you see the state. What is the state law here on this?
The state laws, so far as my lord is concerned, we have got parliamentary enactments in the form.
It's a central statute.
Central statute. State law in respect of Indian Toll Act, it can be because under the entries, my lord, toll is also a state law, my lord. Indian Toll Act, my lord. That part is also discussed in the judgment of, my lord, which the judgment I placed, that it is under the state enactment. So Indian Toll Act, my lord, if you also will see the extent, an act for enabling government to levy tolls on public and road bridges.
No, so your case is this, that because of the central statute, Mines and Minerals Act, which the state has adopted, so any movement in relation to anything as you have shown to us in
Yes.
previous occasion, provisions of the Mines and Minerals Act, which also permit the state only to collect the tolls. So this is in conflict with the customary rights they are arguing.
Yes, my lord.
This 2006.
Yes, my lord.
But you have ratified it as a state, you have ratified it.
Yes, my lord. To an extent, because my lord, if your lordship will see, because entire Khasi Hill district has been divided into various parts. Nongstein is a separate area. But so far as this area is concerned, where this particular toll bridge is there, probably my friend may correct me, because my friend this ilaka is not falling under this act. Because there are small areas, and this is particularly covering Nongstein area, Nongstein CMC. And subject to correction, my friend can, this ilaka, my lord, where this toll bridge has been dismantled, is not under this act. My friend can enlighten us on this aspect, but my reading is that this particular act is not covering. If any other act is there, so far as this toll gate is concerned, my lord. I will also check up.
Yes.
So my submission is not that the provisions are completely repugnant, and even the Guwahati High Court judgment, my lord, will not say, because the basis of that judgment is that no laws have been placed. So,
But
that,
when you ratified as a state,
yes, my lord,
that time this Mines and Minerals Act were very much there.
it was there, my lord. It was very much.
So this
there.
Council 2005,
Yes, my
it
lord.
was sent to you for ratification.
Yes, my lord.
So you ratified it.
Yeah, I ratified it. That's. But the question is, my lord, whether if a tax which is not legal, my lord, will not become legal because government has ratified it. It has to have genesis in law, my lord. 260, Article 265, my lord, subsumed all types of taxes. And that point I have taken in my written argument also, my lord, at page 20 of my written argument. This customary toll is also tax in, or either toll or tax, my lord. That is last page of my written submission, my lord.
Yes.
Imposition of fee by the respondent herein is without any authority by law in contrary to Article 265.
So you are relying upon, from volume 1, which are the decisions you're relying upon?
I am relying upon in volume 1, my lord, the judgments. First, Sadangu El Dakar, your lordship, kindly see the index.
Serial number 1 or 2?
Serial number 1 and 2. Then I am relying on serial number 3, my lord.
Yes.
And 4 I am distinguishing, my lord.
Yes.
5th is on the issue, my lord, that there is no legal right, that I have discussed in my written arguments at page 13, my lord.
Yes.
That no legal rights.
Yes.
And these 3 judgments, estate of Ramchandra Dev, this and Jasa Bhai, Mota Bhai, my lord, on this issue. Now, this Bijoy Emmanuel versus State of Kerala is, my lord, that part I have discussed in my written arguments at page 16 in respect of 19G, my lord.
There is Vijay Emmanuel.
Vijay Emmanuel. That your lordship will find in 16, my lord, page 16 of my written arguments.
Yes.
And Union of India Naveen Jindal is also on that point only, my lord. The other judgments are being relied by my friend Milord, Hinston Construction, Jitendra Kishore Sahu, Mohinder Singh Gill, on the ground that that the affidavit cannot go beyond the original order passed, Milord. That Mohinder Singh, that is being relied by my friend Milord. This is in volume 1, Milord.
No, 10, you are not citing 10, 11, 12, 13?
10, 11, 12, 13 are the judgments I am not relying on. These are the judgments.
Mohinder Singh Gill, the judgments they have relied.
Yes, Milord.
So you are relying up to 1 to 9.
1 to 9, Milord.
Fine.
1 to 9. And in compilation 2, Milord.
Yes. Kaji, T. Kaji, you are relying?
Yeah, I'm T. Kaji, I'm relying, and I'm relying on District Council of GOA, Milord. And in compilation 3, Milord, T. Kaji is repeated and those three. No, sorry. Yes. Compilation
Volume
3 is
three.
only the documents, etc. Milord. There is no judgment.
Oh, compilation 3 is this one.
Yes. And in compilation 4,
Compilation 3 is pleadings.
yes, pleadings, Milord. And in compilation, one more judgment which I am relying in compilation 4, Milord, is on the issue that of the construction of the judgment or reading of the judgment, Milord. In compilation 4, that first judgment I have relied NBCC for the purpose of defining toll and under Indian Toll Act, Milord. And fourth judgment, Milord, Sikandrabad Club versus Commissioner, is on the at page 90, paragraph 21, Milord.
Yes.
In the context of understanding a judgment, it is well settled that words used in a judgment are not to be interpreted.
No, here the words are not written that way. It is, what you are saying is this, you are saying that the judgment of Justice Roy
Yes, Milord.
would not be applicable because the Mines and Minerals Act, which gives a power of the state to collect toll and everything,
Yes, Milord.
this was not considered.
Yes, Milord.
But at the same time, in 2005, when this Kashi Council, this legislation comes,
Yes, Milord.
it has said about custom and customary right
Yes,
in
Milord.
relation to toll for merchandise
Yes, Milord.
and also in respect of the natural resources or minerals.
Yes, Milord. This is the correct. So based on this, Milord, my submission is that the customary toll, particularly on minerals, is repugnant or is against the MMDR Act, provisions made under that. Alternatively, my argument is that it is also a violation of Article 19(1)(g).
How it violates 91G?
Because Article 19(1)(g) contemplates, my lord, that you can put fetters or reasonable restriction by way of law only,
Yes.
and customary practice or customary may not be come within the ambit of law in strict sense, because for that, my lord, even executive instructions have not been treated as law in Naveen Jindal case, your lordship. If I can place that judgment, my lord, your lordship will find the relevant paragraph in my written argument at page 18 and 19. Sorry, page 16 of my written arguments, my lord.
No, they have these checkposts were without the sanction of the law.
Without sanction of the law.
Suppose if you have a right to collect toll,
Toll has to be in form of law only, my lord, and customary law. So their case is that it is a customary law.
so if the customary law permits you to collect toll,
Yes, my lord.
then permission from whom is required for how it infringes?
Lordship, 19(1)(g) confers right on every citizen to practice any profession, carry on occupation, trade, on business. This will be restricted by collection of toll under, this is the collection of toll on every ilaka is a restriction on my right to do the trade business occupation.
See, no citizen has come up and say that my right is being infringed.
Yes, my lord. But if lordship is examining this aspect, because from the purview of or context of reasonable restriction, also, my lord, citizens are not before you, lordship.
No, but have you said that you have put a reasonable restriction? What kind of, see, I may have a right to collect toll tax.
Yes, my lord.
But I may say that, well, you can't have a toll plaza within, say, 10 kilometers.
Yes, my lord.
Maybe it has to be based on some
Yes.
rational basis.
Yes, my lord.
That if it is challenged, one has to find out whether it is a reasonable restriction or not.
Yes, my lord.
But that is not the case here.
That is not.
It's only the only point of consideration is whether they have a right to have checkpost, toll plaza, constructed, erected, and collect the toll tax.
Yes, my lord. That is now in Sadangu judgment, those the single bench division bench judgment, this honorable court held that they do not have right. KHDC has no right.
But has it taken into consideration the earlier judgment?
No, it has not. My lord.
This is Rai's judgment has not been taken into consideration.
It has probably not been placed before. It has not been placed. If lordship will see, the relevant paragraph is 515. But Article 19 aspect has been noted by page 16, paragraph 27, my lord.
Verification. There's nothing to say.
So that is all I have to submit, madam.
Thank you. Yes.
Grateful.
Yes.
My Lord, as I understand the submission of the learned AG, the ground taken by the Deputy Commissioner in the impugned order dismantling my toolkit is in view of the order passed by this report in Sidang case. That is a sole ground taken by the Deputy Commissioner. And that is the pleading in the affidavit also. Now, the argument advanced by the learned AG here is that the law laid down by the division bench by the erstwhile or the High Court in commercial case is not applicable to this case. Because at that point of time, the centerpiece of legislation, MMDR Act, was not brought before the notice of the High Court. And according to him, if I understand properly, the MMDR Act has dealt with this issue, including the customary tolls. Therefore, I have no right to collect the tolls. But I would deal with this issue, but I would impress upon my Lord to look to the background of the sixth schedule. Now, Lordship is very much aware. Briefly, my Lord, if necessary, I will place the Constituent Assembly debates, but I will leave the words of Ambedkar, Dr. Ambedkar. He says that, my Lord, the tribals in India, other part of India, were more or less civilized and cultured with the majority. But the tribals in the Assam at that point of time were still distinct and different. Their culture, way of life is different, more or less similar with the Red Indians in the USC. Therefore, it requires special dealing under the constitutions. In view of that, my Lord, the drafting committee constituted the subcommittee headed by the Bordoloi, the then Chief Minister of the undivided Assam, comprising of the prominent personalities in the Northeast, conducted survey, interacted with many civil groups and enlightened society, and recommendation with the sixth schedule came. And that was debated by the Constituent Assembly 3 days. My Lord, 5th, 6th, 7th, September 1949. My Lord. And Ambedkar said this one, it requires special arrangement. In view of this, my Lord, the sixth schedule, Article 244.2, it is indeed a special arrangement. It is a departure from the general provision of law. In view of the sixth schedule came into being, and then, my Lord, if my Lord see the sixth schedule, before I deal with the pleadings, if my Lord take the pain with me to go through the para 3 of the sixth schedule. Paragraph 3 of the sixth schedule. The lawmaking power of the district council. Paragraph 3 of this, paragraph 3, subparagraph G. Now, this paragraph 3 has given us certain subjects upon the elected district councils to bring law. And this confines to, my Lord, to recognize, sustain the customary social practices, the unique system that is prevailing throughout. And, well, I would straight take to subpara G, appointment and succession of chiefs and headmen. And this, the district council brought the numerous of law. I have given compilation, I will show. 11 enactments I brought before our Lordship notice. Now, the heading appointment and succession of chiefs and headmen. This is the rudimentary tradition institutions spearheading the society from generation to generation. Practicing unique cultural system, social structure, way of living. In view of that,
you see that so far as paragraph 3 is concerned,
yes,
it only recognizes social customs. Collection of toll plaza is not a social custom. It cannot be a social custom. Social custom would mean anything like maybe following some kind of tradition, social tradition. So collection of toll plaza or erection of toll plaza cannot be a social custom. So But if you fall back on 13.2,
Yes.
then it refers to customs.
Yes, I'll come to that.
Huh.
Right. Lordship. Now, the heading G, appointment of chiefs and headmen. This is the traditional institutions. Now, how this survives? They survives with their own revenue system. And that revenue system, the customary tolls, they call it. And different names of the tolls are there. I would invite Lordship attention later on. Now, the sixth schedule did not elaborately mention customary tolls, but the institution has been recognized by the sixth schedule. And district council is empowered to bring law on this.
Yes.
And my lord, before I go to other,
Yes.
my lord, we come to paragraph 8.
Yes.
Power to assess and collect land revenues and impose taxes and collection of tolls. My lord, this is not the customary. Lordship may keep in mind. District council is empowered to collect these taxes. District council is a constitutional authorities. It is not the customary authorities. And these taxes to survive the district council, it is not the customary collections.
No, it can collect land revenue
But
and impose taxes.
yes.
Fee and tax are not the same thing.
My lord. So therefore, what I'm trying to impress, my lord, is that this collection of land revenues, tolls, and fees are this is
Toll
Not
is
a
not a
custom.
tax, toll is a fee.
toll is a fees. Toll is a
So you have land revenue is a collection.
yes,
It's a amount, is a revenue that you earn.
right.
And tax is something quid pro quo. It may not have a quid pro quo, but is required for some. Fee has something else. Fee is a permissive thing. Tax is not something permissive. You have to pay imposition under the article or under the law as it ordains. But there is no provision as such which says that you will have the right to collect toll fees as a customary right.
Yes, it is not there.
Sorry?
It is not here. My lord.
It is not there.
It is not there. Because this
if it is not there-
my lord, this para 8, the taxes mentioned, tolls mentioned in para 8 is not a customary. And I'm not in that.
It's not a customary right. It's a suppose a constitutional body you have a
Yes.
right to collect.
Yes. They have the right to collect and they're collecting. But whereas my collection of customary right is absolutely away from para 8. Is
And
it?
so what you are doing is not covered by paragraph 8.
Yes. Therefore, my right, Lordship has correctly pointed out, my right derive flow from Article 13. That is a protection given by the Constitution. And that was exactly emphasized by the Guwahati High Court. I'll come later on. So since the learned AG argued yesterday that the District Council corpus is governed by paragraph 8, revenues, it doesn't cover to me. Therefore, I have to survive. To survive my institutions, my lord, I have my own way of collecting our revenues. And that customary toll is one of the system. And the British never disturbed. Assam, after my lord, Bengal province, they established Assam province. My lord, they shifted to Shillong. Shillong was the capital of the British region.
But
They did not disturb.
But what do you say after the Mines and Minerals Act come, which give exclusive power to the state to see for the same kind of thing, you cannot have two collections. So if the Mines and Minerals Act gives the state the power to regulate the entire thing, so will it not be in conflict with the customary right you want to enforce?
Yes. Therefore, my humble submission is, my lord, the MMTR Act do not touch upon the customary rights. It has a limited fields. This MMTR Act is operating in different fields, my lord. And customary rights,
No. Insofar as the collection, movement of the vehicles laden with minerals, this exclusively comes in the purview of the Mines and Minerals Act.
Yes.
So, with merchandise, whatever may happen, we may not have to consider, but we are considering a vehicle laden with mineral products, whether that will give you a customary right to collect toll fees in respect of those vehicles. And there you see the Mines and Minerals Act.
This is the volume number 2, my lord.
Yes, if you come to this volume which is given by the supplied by it's a compilation 2.
The compilation 2.
If you come to 23 capital C,
Yes. 22 capital C.
one is illegal mining. It's nothing, we are not concerned.
Yes.
Then transportation. Storage, of course, not.
Yes.
So it says that in particular and without prejudice to the generality of the following powers, such rules may provide for all or any establishment of checkposts for checking of minerals under transit. So this is establishment of checkpost for the purpose of whether you are taking a mineral, which kind of mineral, whether it's prohibited or not, one. Establishment of weigh bridges to measure the quantity of mineral being transported. Then regulation of minerals being transported from areas such and such, inspection, checking, search of minerals, maintenance of registers. So these are the provisions.
Yes.
So if it is check post for the purpose of mineral, is carved out from the main thing, and it has to be considered for a purpose object is there in the Mines and Minerals Act. So that will have an overriding effect.
But the state has the power to erect the weigh bridges to regulate the flow of the mineral.
They will have the right to have check posts.
Yes. Check
They
posts.
will have the right to establish weigh bridges.
Weigh bridges. And I'm not collecting my customary tolls from them. In my territory, my lord, the customary authority, they have their own territory. When the vehicles are entering, apart from others, we collect. My lord, we are not collecting from national highways.
We are not collecting from?
We are not collecting from national highways. It is the state highways, my lord. 5, 6 meters away from the highway, state roadways, we are collecting. So there is no, even the division bench of the High Court said there was no obstructions of the flow of the vehicles. And therefore, it doesn't require permission from the Ministry of Highways also. So indeed, Lordship is correct. MMDR Act deals with a certain degree of fields, my lord, regulating the movement of the mineral-laden vehicles, checking the quantum of the minerals, taking away from the states, collection of the royalties. And Lordship may kindly see at the same page, my lord, page number 72. The same page, may I take page 11 of that compilation number 2. Under MMDR Act, they are collecting the royalties, not the tolls. MMDR has nothing to do with the tolls. Forget about the customary tolls. But even normal tolls, MMDR Act did not deal with it. My lord, kindly see rule section 9. Page 11 of that compilation number 2. At the bottom, royalties in respect of mining leases. And I'll base the judgment later. The holder of a mining lease granted before the commencement of this act shall, notwithstanding anything contained in the instrument of lease or any law enforced at such commencement, pay royalty in respect of any mineral removed or consumed by him or by his agent, manager, employee, contractor, or sublessee from the lease area after such commencement at the rate for the time being specified in second statute in respect of that mineral. So they have the right to collect the royalty. And this royalty collected by the state government is shared between the district council and the state government under paragraph 9 of the 6th statute. Well, I'll come to that. And where, my lord, that Sidangyu case comes into being. And before I take that Sidangyu matter, may I come to the same compilation of the Meghalaya's rules. Why don't we come to page number 72 of the same compilation, 2. This is the rule framed by the state government under the, my lord, MMDR Act. And here also they have the right to collect the royalties. My lord, Rule 28, collection of royalties. Nothing to do with the tolls. And I may, my lord, It may come to, my lord, page number 129 of the same compilation.
'74.
Page number 129, my lord, of the compilation 2.
Yes.
Why don't we kindly say definition, section 2 of section E, check post, mail, all this. And may come to page number 131, rule 3 and 4. Prohibition. Page number 131. Now it says, no person shall transport or carry or goes to transport any mineral by any means from the place of raising to another without being in possession of a valid mineral transport challan in Form A for major minerals, in Form H of the such for minor minerals. Transportation minerals. Rule 4 deals with it. It has nothing to do with collection of tolls. They are regulating the transportation of the minerals. I admit, there is no dispute. But collection of the toll is altogether different. MMDR Act, Mineral Concession Rules, Meghalaya, framed by the state of Meghalaya, has nothing to do with the collection of tolls. It confines to the collection of the royalties, regulating the transportations, quantum of extractions of the minerals through the way bridges and jet gates. In that backdrop, my lord, may I take that impugned judgment, impugned order passed by the Deputy Commissioner, which I assailed, page number 71A of the memo of writ appeal itself, we have it. Annex memo of it.
First.
Dated,
Yes.
like okay, 28 June. I just take the lordship attention again. List of toll gate check gates operating with reference to the subject cited above. I'm enclosing here with a copy of the order to detailing of the magistrates for dismantling of toll gates in East Khasi Hills district. In connection, I'm requested to kindly up depute magistrate in place of Sansa for dismantling the toll gate at Ijamati. This is my placement. Run by Sansa, authorized by Maulong Sidarship, collection of rupees 200 per truck of coal limestone boulder as it was under your jurisdiction. Copy of the High Court order dated Sansa passed in Sansa is inclusive with for reference. Now the sole ground taken by the Deputy Commissioner, he is standing.
2016 order.
Yes. And that 2016 order, my lord, is page, my lord, is available in the same memo of appeal, page number 25. Page number 35 of the same memo of appeal. Read it. And this order was rendered. But I would take the one paragraph. To paragraph, my lord, 33 of the judgment, page number 50. Paragraph 33. In the opinion of this court, the argument advanced by the learned senior counsel for the petitioner has considerable persuasive value, inasmuch as the differentiation of the scenario as far as collection of tolls and the collection of verification fees for mineral-laden vehicles is apparent. The collection of verification fees by the agent of the district council, as enumerated in the case of Sitangyu Dakhar, was prohibited on the ground that there is a law governing the collection of royalty as regards the mineral extracted from within the state of Meghalaya, that is the Mines and Mineral Development Regulation 1957, and the provisions of paragraph 9 of the 6th schedule of the Constitution of India, which speaks about the share of royalty between the state of Meghalaya and district council. However, as far as the collection of toll is concerned, the High Court in the case of Sansaj has taken everything into consideration. Lordship kindly, madam, is absolutely distinct. Madam. Consideration declare that such collection of toll by the traditional and local institutions in the state of Meghalaya to be part of its customary practice, which has acquired the force of. So even Sidangyu case, my lord, learned single bench of Chief Justice acknowledge that the customary collection of customary toll is absolutely different from the collection of royalty under the MMDR Act. And the basis of the rendering the judgment, may I please the pleadings that we have annexed, my lord, that is available. May request, my lord, come to compilation number 3. There, my lord, writ petitions, the affidavit filed by the parties in Sidangyu case, my lord, are annexed. Make a page compilation number 3.
Page?
Compilation number 3, page number, my lord, the prayer in the writ petition, page number 44 of the compilation number 3. That was a prayer. And I was one of the briefing counsel in that case. Page number 44, that was the prayer portion. The relief sought.
I want to raise this.
44 in the compilation 3, 44. And the prayer portion may just come, my lordship. It is prayed that your lordship would be pleased to admit this petition call for the records issues rule calling upon the respondent to show cause as to why the writ of mandamus should not be issued to hold that arbitrary interference by the state respondent, particularly the Deputy Commissioner, West Khasi Hills, Nongsto in Meghalaya, and Respondent Director Minerals Resources into the running of the checkpoints managed by the petitioner for verifying the mineral transport challan, royalty challan, from the coal-laden vehicle originating in the territory of the Khasi Hills District Council as illegal and constitutional, as to why a writ of certiorari should not be issued to direct the Respondent Chief Secretary, Government of Meghalaya, Shillong, Respondent Director of Mineral Resources, and Respondent Deputy Commissioner, West Khasi Hills, District, Nongsto, and Meghalaya, not to interfere with the running and management of the mineral transport, challan, royalty, challan checkpoint at the designated points, namely such and such. These are the points. And the relief. My lord, that point, in that case, what happened? Page number 47, my lord. There was a CHE report. And the CHE came to know that, my lord, the state failed to collect a revenue royalty. And because of the huge crore of rupees, leakage was there. And the district council, one of the beneficiary of the royalty, come up with the policy that we will also, state has established a check gate or weighbridge. And they failed to perform the duties. And crores of revenue has been leakages there. And in view of that lesser collection, I also received lesser amount. Therefore, to assist the district council, let us establish a checkpoint. And when the trucks, my lord, the mineral-laden trucks pass through the weighbridges of the state, we will also verify in our own check gates whether, my lord, the vehicles are carrying the exact metric tons, my lord, or paying the royalty or not. They come up with this, my lord. And, my lord, the public notice might invite, my lord, page number 137. 137 of the same compilation, third compilation. This public notice was issued on 10 December 2015. It's an open tender process. And Mr. Sidangyu came forward as a tenderer. And in view of his success, my lord, successful tendering, my lord may come to page number 140, the terms and conditions of his appointment as the agent of the council. Page 140. It says terms and conditions guidelines. But the councils intend to appoint an agent, it says. Page 140. But the appoint agent for checking of mineral transport challan MTC or royalty challan carried by all the mineral laden vehicles originating from the council's territory. Now, I come to relevant portion, the next page straight away, my point number 14. Let's say Lordship's time. The next page, page number 141. Point number 14. He was allowed, the operating expense fee allowed to be collected from the MTC mineral transporter after verification of royalty challan and related papers shall be 100 per vehicle of 6-wheelers and 4-wheelers, rupees 200 per vehicle from double XL's vehicles and above. So he was allowed to collect this. So this was interfered by the state government. And he filed writ petition before this honorable court. And the affidavit, my lord, in that case, my lord may kindly come to page number 153. The affidavit filed by the state government in that case.
No, are you claiming yourself to be an agent? Because this was terms and conditions and guidelines issued for the agent for checking of mineral transport challans.
Yes.
The document that you have shown was 140.
Yes.
So what is it? And there is also operating expense fee. So why you are showing this document to us? For what purpose?
But he was, my lord, he was allowed to verify the transport challan from the vehicles. And as a fees, he was allowed to collect this 200 rupees, 100 rupees. And the state has challenged this one. State say that you are not authorized to, this town has no power to appoint the agent to collect the fees because we are collecting the royalties from own weighbridge and checkpoints.
So
Yes.
royalties are collected. The agent shall, the operating expense fee allowed to be collected from the MNTC
Yes.
after verification of royalty challan
Yes.
and red papers. So this fee will be collected from the MNC
From the vehicles.
after royalty challan.
Yes. Royalty challan has been, my lord, royalties has been collected by the state in their own weighbridge. And after crossing the weighbridge of the state, it comes to my checkpoints, transport challan checkpoints. And this appointee of district council verify the same vehicles. And for the purpose of the verifying, the agent was allowed to collect this 100 rupees, 200 rupees. And the state has challenged this, that you don't have the power under the MMDR Act. And that affidavit, my lord, is page number 153, filed by the director of the Mineral Department. My lord, they admit, and I would straight away come to para 9 of that affidavit, page number 155. Para 9, page number 155. It says, with regard to the averment made in paragraph 19, 20, and 21 of the writ petition, the answering deponent states that in order to check payment of royalty by the coal-laden trucks, the Directorate of Mineral Resources is operating check gates in various locations of the state. The check gates are located only at designated exit points as approved by the Honorable NGT in the guidelines dated 1st September 2014 and its subsequent orders. So they have taken the plea that I'm the only person who can collect this royalty, not the district council. Therefore, kindly shut down. So that is the end. My lord, Deputy Commissioner affidavit. My lord, the reason why I, my lord, impress upon my lord to take the pain to go through is that the learned AG has taken the ground that Sitangyu case covered my case. My lord, here in the state affidavit, it has nothing to do with the collection of the customary tolls. This is the affidavit of the director on behalf of the state. And I would go to page number 158, the affidavit.
Mr. Advocate General, and also Counsel, you see that we are thinking of this subject to whatever we said. The order issued by your authority, the judgment on which is relied upon, has nothing to do with the right he exercised in the writ petition.
Yes, my lord.
So we say that the basis of the impugned order, based on the said judgment, is wrong. If there is any other right what is urged, that has to be considered by you and you dispose it of.
Yes, madam. I have no issue. Only thing that the observations made by learned single judge should not come in my, because there are findings recorded by learned single judge. That findings will come in my way. Saying that I am because learned single judge has not decided the matter on this ground. And learned single judge has decided the matter on the ground, or the issue on the ground, that the case of petitioner is covered by Guwahati High Court bench judgment.
We keep all points open, so it will be open for them also to take this point before you.
Yes, madam.
And then you decide the matter,
Yes,
because we may not have to at this stage.
Yes, madam.
We may not have to go to the minds
All
and
the
merits of the
issues.
rights.
Yes, madam.
But the order is going to be set aside. The order
Yes.
is wrong.
Yes, madam.
My lord, that order was already set aside by the single bench, the single bench.
We can dispose of this
Yes,
matter.
my lord. On these short points, there is no issue.
Okay, now, we have heard the land counsel for the parties extensively. Full stop.
conflict with Sadangu, it is not based on that. Learned single judge has applied two parameters. One is that Guwahati High Court bench judgment.
We have said so that we do not find that the